TCL as well as from other NTPC projects.
Good afternoon, ma'am.
Good afternoon, sir. Good afternoon, Ashok Goyal, sir.
Yeah.
Our faculty will be joining us in another 5 minutes as he is currently held up in a webinar meeting in his office. So, meantime, we'll also have other seniors of NTCL who will be joining with us very, very shortly. Meantime, I request your kind patience. Our safety officer, our DGM Safety NTCL has sent me to ask few questions from all the participants. How many of us are already aware of this particular code, Occupational Safety, Health and Working Conditions Code? Participants may kindly use the chat box or even unmute your audio to share your answers.
Ma'am, this OSHWC we know, but that particular code you are asking, that could not be maybe something new one or some revised one. No? OSHWC we have in NTPC earlier this was following 14,001.
Okay, sir.
Yes, sir, it is not about what are 2001 or it's all a new code which was brought in, bringing a lot of legislations on a single platform by Government of India. The recent past, 2020, this code was approved by Parliament and President of India. Existence now, all are taking groups. They're all going to come state. In Gujarat, they have already brought down rules on this voice code. Is it correct, Sujit?
Yeah, maybe it's new one, so let us.
Yes, Dr. Langovan sir has also joined. Mandal ma'am, you can see.
Yes, sir.
Yeah, madam, I'm online. So shall we wait for some time for the members to join?
Just 5 minutes. Our CEO sir is joining. I'm just ringing him up. I'll ring up and I'll just coordinate with him, sir, for him to join the session.
Please.
Just 2 seconds, sir. In the meantime, would you like to share your screen and test the PPT, sir?
Do it first. Let me started, so that I am already ready with my presentation.
No. Oh, super, sir. All right, sir. Thank you, sir. Elangovan sir, our CEO sir has sent us a message, sent us a word that he will be joining shortly, and he has asked us to. He has given a green signal for us to start the session, sir. So shall we? Elangovan sir, are you with us, sir? Sir, am I audible?
Yes, audible, ma'am.
Okay, sir. Thank you, sir. Elangovan sir, are you with us, sir?
Ma'am, sir is with us, I think. Can start, ma'am.
Shall I go start, sir?
Please start, please start.
Okay, sir. So a very good afternoon to one and all. Safety is the lifeline of all our NTPC practices and procedures. To build a safety culture and to reinforce safety practices amongst our employees, NTPC and NTCL has brought out a plethora of awareness initiatives like safety policy, inclusion of safety parameter in PMS, compulsory safety awareness program for all its newly promoted GMs, and etc. In order to enhance the safety skills and to make safe working practices a habit, NTCL EDC, in consultation with Safety Department, has been organizing various safety programs in a periodic manner, covering various safety aspects of power plant. And today, we are covering a session on safety legislation, Occupational Safety, Health and Working Conditions Code 2020. The Occupational Safety, Health and Working Conditions Code 2020 is a code to consolidate and amend the laws regulating the occupational safety and health and the working conditions of the persons employed in an establishment. The Act replaces 13 old central labor laws, and to name a few, say Factories Act 1948, Contract Labor, Contract Labor Regulation Act 1970, Interstate Migration Workmen Act 1979, Mines Act 1952, the Building and Construction Workers Act 1996, and etc., which are of importance to our power sector. As our CEO NT Shri K.R. Pandu sir always mentions, every employee ILF is a mantra of NT safety before production is the lifeline of all our practices. And having a knowledge of this particular code, Occupational Safety, Health and Working Conditions Code 2020, which is going to be implemented very shortly in India, will have a greater say in the way that we operate in a power plant. And considering that, today we have with us a veteran faculty with us, Dr. R.K. Ilangovan, Director General, who has joined us via MS Teams from Mumbai, from his office, to facilitate this wonderful session for us all. And with the permission of the group, I would like to give a small glimpse about the profile of our faculty, Dr. R.K. Ilangovan, sir. Dr. R.K. Ilangovan, sir, is working as a Director General and Chief Inspector of Dog Safety in the Directorate General Factory Advice Service and Labour Institute, DG Fastly, Ministry, which comes under the Ministry of Labour and Employment, Government of India, Mumbai. He holds a gamut of degrees as qualifications, starting from he has completed his BE in Mechanical Engineering from College of Engineering, Guindy, Anna University, MSc in Environmental Science from Bardher University, PGDBA from Annamalai University, MTech in Machine Design from IIT Madras, PhD in Industrial Safety from Alagappa University, Karaikudi. He is a member of many doctoral committees of the academic research programs in the field of occupational safety and health. He has been selected and included as an industrial safety expert in 2020 edition of Marcus, Who's Who in the World, distinguishing him as one of the world's foremost achievers in the field. He is an expert faculty in the field of occupational safety and health and has been a chairman or the member secretary of various technical committees on OSH formed by central and state governments. He is a lead safety auditor and has completed ILAB, India Occupational Safety and Health Modernization Program Trainer Academy, conducted at University of Texas at Arlington, Texas, USA. He has represented India in G20 Occupational Safety Health Network, Rotterdam Convention, and also various other international programs on occupational safety and health. He coordinates with DGUV Germany on implementing occupational safety health program in India. He has also organized various seminars, workshops, and training programs on occupational safety and health, and has conducted many studies in the field of occupational safety and health, noise and illumination study, safety audit in factories and construction site, on-site and off-site emergency plan, HERA, quality risk analysis, hazard, and HAZOP studies. He heads the expert committees on framing occupational safety and health standards under Section 18 and rules under Section 23 and 24 of Occupational Safety, Health and Working Conditions Code 2020 pertaining to the factories and dock work, and coordinates with the other two expert committees on building and other construction work and fire safety. He is actively involved in occupational safety and health activities for over 3 decades and has published many thematic and research papers and articles in this field. Let's give a very, very warm welcome to Dr. R.K. Langovan, sir. Sir, we are very glad to have you on this wonderful session. And not taking much time, I now hand over the floor to you, sir.
Yeah, thank you, madam, for your very detailed introduction. And before I start the presentation, what is the timing we have fixed? Shall we go for 1 hour or 1.5 hours? What's your thinking?
We are ready to hear to you even for 2 hours, sir.
Yeah. But I have 2 other.
It's a pleasure to have you.
Let me try to make it 1 hour presentation and discussions.
Yes, 1.5 hours will
that's
be okay,
including discussion. We'll keep it 1.5 hours. And I would also request the delegates to please raise your questions whenever it is required. Let's not wait for the end of the presentation. I will right now share my presentation and then share my screen and start the presentation.
Yes, please.
Okay. Whether screen is visible?
It was visible.
No, sir, it is not visible.
Okay.
Now it is not.
Now it's not visible.
Now is it visible?
Yeah, it is visible, sir.
Yes, sir. Now it is visible.
Whether the screen is moving? Sir, I come to the second slide. Whether the screen is moving?
It is the first slide only.
Wait, that's the problem. Normally we work it 1 second. Now is it visible?
No, sir.
No, sir.
Now? No.
Your screen is visible, sir. Your screen is visible, not presentation.
I don't know. Because I'm going for this thing and window also. There's some technical errors, I don't know. Yeah, now you see the presentation, right?
Yes, sir. Yes, sir.
Yeah. Sorry for the inconvenience. So we'll go with the presentation, and it's a very detailed legislation. It will be difficult to cover the entire legislation in 1.5 hours. I will try to give an overview of this code.
So it will be better if you go to full screen mode, sir. Full screen mode.
Full screen, no, what happened? The screen is not moving. Suppose I move it. Now you see screen is moving.
No, sir.
No, not moving. That's the issue. When I put it in full screen, it is not moving. Let me run this, then let's see. Honestly, let's not waste time. Now my screen is visible, right?
Yes, sir.
Yes, sir.
Okay, sir. Thank you. So basically, this code, all of you must be knowing, the Government of India has come out with 4 codes amalgamating 44 legislations. And these 4 codes are like industrial relations, or we have codes on industrial relation, occupational safety and health, wages, social security. So this code on safety and health and working conditions is purely dedicated to safety and health. Apart from that, there are also other legislations which are covered under this code. By and large, it subsumes 13 legislations. When I say subsume, that the legislations will be absorbed by this code. And among these 13 legislations, we have Factories Act 1948, Mines Act 1952, Building and Other Construction Workers Act 1996, and we have Plantation Labor Act, and we have Dock Workers Safety, Health and Welfare Act 1986, and the rules and regulations made thereunder. And if you see, as I told you, the 44 laws are dealt by the Labour Ministry, and so almost 12 are repealed and subsumed in 4 codes. 29 legislations are subsumed under this code. And you can see, number of acts subsumed. The discussion today, code on wages, it subsumes 4 acts. Code on safety, health and working conditions subsumes 13 legislation. Code on IR subsumes 3 legislations. Code on social security subsumes 9 legislations. And this is the overall framework. There are almost, you can see, Code on occupational safety and working condition. We have almost about 622 sections under these 13 acts. And the code proposes around 143 sections. You can see basically how these sections are changing. So coming to the code on wages was notified on August 8, 2019. And draft rules have been published for stakeholder consultation on 7th July 2020. We have this Occupational Safety and Health Working Conditions Code 2020, which was introduced in Lok Sabha on July 23rd, and Standing Committee submitted a report on 11th Feb. And the bill was introduced in the Lok Sabha and has been assented by the Honorable President of India in the month of September 2021. The IR code will introduce in Lok Sabha on 28 November 2019. Standing Committee gave report on 24/12. The bill introduced in Lok Sabha. Then there's the 4th code, Social Security Code. It was again introduced in the Lok Sabha on 11th December. And the bill again introduced after the Standing Committee report on 19/9/2020. So basically, the codification process converting these laws into codes, 1 registration, 1 license, 1 return, minimum forms. This is, user friendly, compliance friendly. This is a very important issue here. And the definitions are very uniform. There won't be any changes in the definition or variation. The number of committees under all these laws reduced. It proposes web-based randomizing jurisdiction-free inspection. And introduction of technology, the law, the code, the rules, standards thereunder proposes electronic registration and licensing. It aims towards reducing the compliance cost and litigation. As I told you, we have 13 labor law, acts have been consolidated. And the code envisages standards. Basically, this code provides for standards on occupational safety and health, rules and regulations. These are the 3 things given under the code. I don't want to go because we'll be seeing it. These are the legislations which I had explained. The first 5, factories, mines, dock workers, building and other construction workers, plantation laborers, are the 5 original jurisdiction legislation. The legislations which are having original jurisdiction, and there the safety, health and working conditions are taken care. The Contract Labor Act, the interstate migrant worker, then working journalist, again working journalist, fixation of rate of wages, Motor Transport Workers Act, sales promotion, BD and CR, cine workers and cinema theatre workers will all also be part of this code. The code currently, it has 14 chapters encompassing 143 sections, and it has 3 schedules. This is what the code is about. Very crisp and very procedural way of putting things. So the important point of this code is that already the code has been notified, assented by the Honorable President. The government, central government will take a call on when to implement the code. And the code has been aligned with the Child and Adolescent Labor Prohibition and Regulation Act 1986. Therefore, the definition of child, a child who has not completed 14 years, will prevail over the code, and all the ages prescribed under the law will be applicable to the code. There won't be any employable child, what you find in factories as of now. And it defines agent in case of a mine. I think this is related to your mines under Mines Act. Since now it is part of the code, the agent is also defined. The law talks about two things. One is appropriate government. It talks about state and central government. They are the two appropriate governments. The principle here is that the central sphere, central government will carry out. Other than central sphere, state government will carry out. But in case of factories, the government has declared the state government as the appropriate government for the purpose of factories. This is the definition of building or other construction work, which we have brought in under this code. And also you will find we have the competent person under the current legislation has been retained. The contract labor has been well defined under the law. A worker shall be deemed to be employed in connection. In fact, establishment, I'll come to it a little later, when he is hired or in connection with such work through a contractor. Then contractor is also defined. Any person who undertakes to produce a given result for the establishment, other than a mere supply of goods and articles, are manufactured to such establishment through contract labor. And supplying contract labor to work in an establishment is also a contractor, manpower supplier. Then the entire code talks on two principles, employees, workers. In terms of factory, there are two different definitions. Employee is an individual, a person employed on wages by an establishment. An establishment includes factory also. To do any skill, semi-skill, unskilled, manual, operational, supervisory, managerial, administrative, technical, clerical, or any other work, whether the terms of employment be expressed or implied. So this is the definition of, that means everybody in the organization comes under the employee definition. You can see manager is also employee, managerial capacity, administrative capacity, technical, clerical, or any other work connected with an establishment. Everyone will be called as an employee. Of course, it doesn't include armed forces of the union. And this is mine. Then there is another definition, employer is a person who employs, whether directly or through any person, on his behalf or in behalf of any other person, one or more employees in his establishment. So if it is government, central government or state government, the authority specified or the head of the such department, he will be the employer. And in case of factory, you can see U1, the occupier is the employer of the factory. So mine, you will find the owner of the mine, agent, manager, they're all the employees. And the law also prescribes the contractor is also an employer. Legal representative of a deceased employee is also an employer. So suppose the employer is died, is dead or something like that, his legal representative will enjoy the employer status. And they introduced a session on establishment a definition, you see the current system of factory, manufacturing process, dock works, all are changed now. This is in line with the constitution provisions. It's a place where any industry, trade, business, or manufacturing is carried out. So wherever an industry, trade, business, manufacturing, or occupation, everything is part of the establishment. And if is the motor transporter working, newspaper establishment, audio visual, building or other construction work, there should be a minimum of 10 workers. Factory, of course, they have said 10 for the purpose of coverage. For the purpose of implementation, the code says 20 or more workers with power or 40 or more workers without power. The mine or a port will be with the independent of the number of workers. And this is the definition of a factory. 20 or more workers. Existing 10 will be shifted to 20. 20 or more workers are working in any day in the preceding 12 months. And wherein 40 or more workers are working in any day in the preceding 12 months without power, without the aid of power. These are the two important differentiations we have. And you can see this is the without of aid of power. And here you come with the aid of power. That's the difference between the threshold part. And I will skip, because this presentation you can see almost 365 slides. I just skip. If you want anything to be explained, the delegates may interrupt and then you can put the point so that I will discuss on it. Then we have defined godown also, a warehouse or other place, by whatever name you call it, used for the storage of any article or substance. So the code is applicable to the godowns also, where it could be a warehouse or other place. Then the definition of hazardous process, in fact, it is the same under the Factories Act. That is again specified in the first schedule of the code. Only difference is current the Factories Act has 29 industries as hazardous processes, whereas under the code, this 29 has been expanded to 40. And the qualifying criteria is clearly same. The raw material, the intermediate or finished product or byproduct, hazardous substance, waste or effluent thereof, spraying of pesticide, insecticide or chemical use therein, as the case may be, would cause material impairment to the health of the persons engaged or results in the pollution of the general environment. These are the two categories of reasons for categorizing an industry as a hazardous process. The code also defines hazardous substance, any substance or such quantity of the substance as may be prescribed by the appropriate government or preparation of which by reason of its chemical or physiochemical properties or handling is liable to be cause physical or health hazard to human being or may cause harm to other living creatures, plants, microorganisms, property or the environment. Now the entire law changes the inspector terminology to inspector cum facilitator. After the code is implemented, she will be called as inspector cum facilitator, not the inspector. This code also defines machinery. And you can see article, a combination of articles assembled, arranged or connected, and which is used or intended to be for converting any form of energy to perform work, or which is used or intended to be used, whether incidental thereto or not, for developing, receiving, storing, containing, confining, transmitting, transferring, and controlling any form of energy. Please, is it? Are you raising a point here?
Sir, please continue, sir.
Was it? No, you're not audible. Madam, can you?
It's okay, sir.
Huh?
It's okay, audible.
Please continue, sir.
Sir, no, somebody had unmuted, sir.
Yeah,
They
please
have
ask
been
them to
unmuted, so not a
put their
problem.
mics
Sorry.
in mute mode, otherwise it will affect the presentation.
Yes, sir.
And
I'll
you
ensure.
can see here the manufacturing process, it has been defined. The same thing what we have incorporated, where we have said making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing or otherwise treating any article or substance with a view to its use, sale, transport, pumping of oil, water, sewage, renew the substance, generating and transforming and transmitting power, composing, printing, letterpress, lithography, offset, photograving, and so on. Constructing, reconstructing, repairing, refitting, finishing or breaking of ship or vessel, preserving articles in cold storage, and again the government, central government may notify any other process. The section 2 is a J talks about medical officer. This terminology is replacing the terminology called certifying surgeon. It is basically medical officer appointed by the government under section 42(1) of the code. And the code is applicable to metro railway also. As I told you, it's a trade, industry or commerce. So it's applied to all the places. Then the case of definition of occupier, the person who has the ultimate control over the affairs of the factory. In case of a firm or other association or individual, any one of the partner or member, company, any one of the directors except any independent director. So the independent director cannot be an occupier. That is what I clearly explained. And if the factory is owned by central government or state government, a local authority, then such authority has to be prescribed by the central government. Central government will prescribe which will be who will be the occupier in case of government owned or controlled factories. Then we are using the term ordinarily employed. It refers to an establishment, means the average number of persons employed per day in the establishment during the preceding calendar year obtained by dividing the number of man days worked by the number of working days, excluding the rest days and other non-working days. Earlier, this ordinary employed was 2/3. Now they have said that you should work it out, how to work it out. Then this definition in case of mine, I'll skip it. Then we have qualified medical practitioner. I already told you, they are defined. The person who possesses medical qualification under the Indian Medical Council Act and enrolled in an Indian Medical Register and on a state medical register. Schedules, I told you, there are 3 schedules under the code. Same way, one is the first schedule is regarding the hazardous processes. Third schedule is notifiable diseases. The second schedule is the power to make standards, list of standards. Then the serious bodily injury, which is so far not defined, the existing law has been defined. Any injury which involves or in all probability will involve the permanent loss of any part or section of a body, or the use of any part or section of the body, or permanent loss or injury to the sight or hearing, or any permanent physical incapacity, or the fracture of any bone, or one or more joint, or bones of any phalanges of hand and foot. As I told you, this law code provides for standards. And you see the entire occupational safety standards under the code will be declared by the central government. The state governments will be implementing it. The central government will prescribe standards, regulations, rules in terms of the law. And I'm skipping way that's and the worker is defined. The worker is the person who is employed in an establishment to do many manual, unskilled, skilled, technical, operational, clerical, and supervisory work. Only thing is, if the person is working in managerial or administrative capacity or in supervisory capacity drawing more than 18,000 rupees per month, then she will not be a worker. This is the biggest change. So a supervisor is a worker, but he will not be eligible to be called as worker if he draws more than 18,000 rupees per month. That's the change point. And supervisors working in managerial or administrative capacity cannot be called as worker. We come to the chapter 2 of this code.
Excuse me, sir. May I question, sir? You are talking that more than 18,000. Nowadays, I think HSW or maybe SSW may be getting more than 18,000. So how come it is possible that he will not be a worker?
See, under the current circumstance, anybody who is working in supervisory capacity drawing more than 18,000 rupees per month will not be called as a worker. He will be an employee alone.
That is true, sir, but some supervisor are working as a HSW category, high skilled worker. Under that category, they are doing their jobs as a supervisor.
So what category you are talking?
Pardon, sir?
No, what is it you are trying to mention? Which category?
HSW, high skilled worker, maybe skilled worker, because as per minimum wages, it is more than 18,000.
Okay.
As per minimum wages of present scenario, they would be getting more than 18,000 and working in supervisory category. So whether he will be worker or
he will not be a worker.
Will not be a worker.
That's
whether
why.
it is HSW, SSW, whatever it is.
Whatever. See, you please see the definition. Is it L first para? A person working in supervisory work for hire or reward is a worker.
Yeah.
But doesn't include any such person. He is a worker, but he will not be considered as worker because he draws more than 18,000 rupees per month.
Okay, this is the new amendment, sir.
This is the current code. This is the code contains this.
Okay. Okay.
For example, tomorrow government is going to increase 18 to 25. They amend it, then they may cover.
Okay.
Currently, it is not possible because he is a worker. It's not considered as worker because of the wage. Yeah.
Thank you.
That's the right question you asked. And this coming to chapter 2. I think any other question in the chapter 1? Okay. So coming to chapter 2.
Sir, my question is, if he is a worker, skilled worker, but not of a supervisory category, then but he is drawing more than 18,000, whether this code is applicable?
See, again, it's the right question again. Worker, there is no wage. You see, manual, unskilled, skilled, technical, operational, clerical, there is no wage limit. Only the person who is employed in a supervisory capacity, drawing more than 18,000 is not a worker. So a worker working in worker category and drawing more than 18,000 still is a worker only. Agree?
Okay, sir.
Only the designation matters here, sir. What designation the establishment is giving to the worker, whether it is a supervisory or it is a worker, isn't it?
That will be decided by the management and is by nature of his work.
Right.
You agree with me?
I think it would be by nature of work because deciding anybody.
It is nature of work only. I'll tell you again. See, a worker, manual, unskilled, skilled, technical, operational, clerical. In those categories, there is no wage limit criteria.
True.
He will continue to work because these are the nature of work. Only a person working in supervisory capacity. Please understand the point number 4. When he draws more than 18, he is not a worker. Otherwise, he is a worker.
One question. One question,
wage
sir.
limit is applicable to the people working in supervisory capacity only.
One doubt is there, sir.
Yeah, please.
When we engaged workers or supervisor through contractor, we call the supervisor, but he actually for NTPC he is the worker only. However, his designation given by the contractor is supervisor. So for NTPC it will be only a worker only, isn't it?
Okay. What is the line used? Supervisory capacity. If he is working in supervisory capacity, how can it see? You call worker, you call employee, you call outsource, you call guest. That is your terminology. It is the type of work he is performing. Supervisory work or supervisory capacity. We don't call him as a supervisor. There's a difference between calling a person supervisor and a person performing supervisory work or working in supervisory capacity. They are different criteria. Do you agree?
I didn't get you, sir. I didn't get you.
See, okay.
Actually, it is like that. It is a supervision. Supervision of some particular jobs, and supervisor is who is doing job basically.
Sir, I'll explain it. We are talking about the work performed by him, not by his designation. That's point number one.
Okay.
So work performed can be manual, unskilled, skilled, technical, operational, clerical, or supervisory work. It is the work performed, not the designation. So when a worker is doing when a person is doing a supervisory work, he may not do the manual or unskilled, skilled or technical work, operational work. Then he'll be supervisor only. Whether you call him worker, that is no matter. He is working supervisory capacity.
Oh, okay, got it.
For example, you have a contractor. I'll explain the case which you talked. The contract employees are workers. Am I correct? So the the contractor may have 2-3 people as supervisors working supervisory work, carrying out supervisory work, or working in supervisory capacity. They can't be called as a worker. And this definition is based on the type of work carried out by him. And you see the another point 3, the persons employed in a managerial or administrative capacity, वो भी worker नहीं है. You may call him worker, but he does a manager job or an administrative job, then he can't be a worker. You agree or you want to have any other points, please?
No, sir. Right, sir. Right, sir. Got it, sir.
Okay, thank you. So coming to the registration, it is a single registration under the code. And in fact, all the establishments should register within 60 days from the commencement of the code electronically, no physical applications. It will be done through a portal or website, and the registration will be auto-generated. And all the factories employing 10 or more, they have to register, but they will not be applicable for enforcing the law. And I will skip all this provision. Then we have a provision on appeal. If your registration is rejected by the concerned officer, appropriate authority, then you can file an appeal within 30 days from the date on which the order is communicated to you. This to the appellate officer. All these registration appellate will be electronical. There is no need for physically sending anything to any authority. As well as now the employer has the responsibility, the employer of the establishment, whether factory, mine or contract labor or wherever it is, he should intimate on the commencement of the work as well as cessation of operation. Closure as well as startup, dono, he has to inform to the concerned authority. Concerned authority prescribed under the law. Then we come chapter 3, we talk on duties of employer, employees. The first thing is duties of employer. If you see this entire legislation, this is based on Factories Act 1948 by and large as a base document, and that is made applicable to all the establishments. So if the employer has to see that workplace is free from hazard, comply with all the standards, rules, regulations, and you should also have health medical examination free of cost, provide and maintain a working environment which is safe and without risk, disposal of hazardous and toxic waste, including e-waste, and they should also issue letter of appointment to every employee in his establishment as per the requirement. Okay, so these are the duties of the employer.
Sorry to interrupt you, sir.
Yeah. Please.
But that part is there in under factories, and if it is same, so that part you can skip it, sir. I hope others will not mind it. But we are aware about that part. Whatever there is.
I am not going to factories. This has been changed. Now you have section 7A, duties of the occupier, right? But the concept has been taken, but it has been modified. I said by and large, it has been taken as the base. It is not as it is.
Okay. Oh, okay, sir. Okay, sir.
Now you see employer duties of employees there in section 7A of the Factories Act. But you see here we have said the government has said comply with the standards laid down under section 18 and rules and regulations under this code. This is not there in the Act. I just gave for an information that the layout of the Factories Act has been taken into account.
Okay. Okay, sir. Right, sir.
And there are a lot of modifications. For example, you say section 8, we talk about designers, manufacturers, importers or suppliers. The manufacturer, importer, supplier comes under section 7B of the Factories Act. But whereas designers, that comes out with the construction OSHWC Act. They all put together and they are given duties for the designer, manufacturer, importer or supplier to see that whatever is designed or constructed is safe without risk, carry out such tests and examination and so on. Then we have duties of architect, project engineer and designer. And this is, you can see here, this is basically for the building or a construction work. It is clearly prescribed. In case of a OSHWC site, the designer, architect and project engineer have a duty to see that due consideration is given to safety and health aspects of building workers and employees who are employed in the erection, operation, execution of such projects and structures as the case may be. Then comes section 10, notice of accident. It's same way, if an accident occurs within 48 hours or immediately, there should be a report of accident by the employer or owner, agent or manager. In case of a factory, it is employer and manager. And there is also section 11 talks about dangerous operations, dangerous occurrences. Basically, it is collapse of building, machinery, structure, fire, explosion and release of toxic substances. So these dangerous occurrences should be reported by the employer. And notifiable diseases, as listed in the third schedule. Yes. Are you speaking to me or speaking somewhere else? Sir, please mute your mic. So any worker who contracts any disease specified in the third schedule, then again the employer have to send the notice of occurrence of such certain diseases, notifiable diseases in his factory. And we have also said the existing provision, if any medical practitioner attends to a person, he need not be a factory medical officer, and he comes to know that a person is suffering from any disease specified under the third schedule, and he is supposed to send the report to the CIF, Chief Inspector cum Facilitator. And if the concerned qualified medical practitioner fails to comply with the provisions of so-and-so, he shall be punishable with a penalty which may extend to 10,000 rupees. This is something we have in section 89 of the Factories Act. Now it is applied to all. Then we also have duties of employees. Employee shall take care for the health and safety for himself as well as others, comply with the safety requirements specified in the standards, cooperate with the employer in meeting statutory obligations of the employer, and if any unsafe or unhealthy situation comes to his attention, report the situation to the employer or the health and safety representative, safety officer, and he shall not willfully interfere with or misuse, neglect, or any appliances, convenience, or anything provided for the purpose of securing health and safety and welfare of workers. Do not willfully and without reasonable cause anything likely to endanger himself or others, and perform the duties. Then comes rights of the duties. Then now comes rights of employee, and right to obtain information from the employer regarding employee's health and safety at work, represent to the employer directly or through the safety committee the purpose regarding inadequate provision for his protection of his safety, health, and connection with the work activity in place. And if not satisfied, he can appeal to the inspector cum facilitator. Then we also have section 15, overall generic provision. No person shall intentionally or recklessly interfere with, damage, or misuse anything which is provided in the interest of health, safety, or welfare under this code. That's duty not to interfere with misuse or misuse thing. So you see chapter 3, all duties, employer, employee, and then of course you also talk about the importers, design, architect, and we also have rights of workers, then duty not to interfere or misuse things. So chapter 4A is purely on occupational safety and health. Up to now, do you have any suggestion or points to discuss? The delegates may raise. So I presume that there are no points, so I'll move on to the chapter 4.
Sir, good afternoon.
Yeah, please.
Sir, now these duties and rights of employee was discussed. So this sometimes back worker definition was given. So worker and employee both are coming in the similar meaning. Worker and employee.
I will put you like this. Your worker is employee.
Yeah.
All employees are not workers.
Yes, correct. Because supervisors.
In employee definition, the person working in administrative capacity, managerial capacity, supervisory capacity is also an employee.
Yeah.
Worker comes to a very focused point who does manual, skill, semi-skill, unskilled, clerical, and supervisory. And we are saying the person working in administrative and managerial capacity is not a worker, but he is an employee. Same way, supervisor drawing more than 18,000 is not a worker, but he is an employee.
Okay, correct.
So all employees have the duties,
okay,
rights.
Correct. Agreed. Got it. Thanks.
Okay. See, this occupational safety net, the whole system of OSH management in the country has been revised, or I would say are supposed to be modified. So the code, under section 16 of the code, the central government provides for constituting National Occupational Safety and Health Advisory Board, hereinafter referred as National Board. The board is called National Occupational Safety and Advisory Board. It will be the highest board in the country. And his job is to advise the central government in framing standards and rules and regulation, implementation of the provision of this code, and issue policy and programs and other matters referred by the government. So the central government constitution of the National Occupational OSH Board, National Occupational Safety Advisory Board, this board will develop standards and rules and will recommend to the central government, and central government may accept it may take a call and make it as a part of the law. That will be headed by Secretary Labour and Employment. DG Fathi is a member, DGMS, Chief Controller of Explosives, CPCB, and Chief Labour Commissioner, and 4 states, Principal Secretaries of Labour of 4 states by rotation, Director General ESIC, DG Health Service, 5 representatives of employers, 5 representatives of employees, and a representative of professional body associated with the matter for which is a member, and 5 eminent persons connected with the field of occupational safety and health, including the representatives from reputed research institutions. They are all the members. There will be Joint Secretary, Ministry of Labour and Employment Member Secretary. And of course, special invitees also are there. And after this, it also provides for same board in the state level, State Occupational Safety and Advisory Board. And they are advising the state government in administration of this code, not framing standard. The function-wise, they are different. Whereas the central national board will set standards, set rules, advise the central government on standard, rules and regulations, whereas state government will only advise on matters, arising with the, administration of this code. And you will also see, we come to the important point of the entire crux of this code. The central government will declare standards on occupational safety and health for workplaces, factory, mine, dock work, BD and CIGAR, building and other construction work, and other establishment. And if you see, now these standards will be declared by central government. State government will not declare standard on safety and health. They will only implement the standards declared by the central government, number 1. And these standards will be notified under Section 18 of the code, and that will be applicable throughout the country. It is similar like one country, one safety and health standard. This is what completely it is coming to the system. And you must be knowing the government has formed 4 expert committees to frame standard, factories, docks, construction and fire safety. And as a DG of DG Fastly, I'm heading 2 committees on factories and dock works in framing standard, safety and health standard. We have already submitted the OSHWC standards regarding dock work to the Common Ministry, and we are in the process of completing the occupational safety and standards for factories, and we hope to complete and submit to the government end of this month. In fact,
one doubt is there. Do you mean to say that earlier under Factories Act, the state government has given power to frame the some regulations? So that power will not be there with the state government right now under this code.
I didn't mean that. I'll tell you the other way. Earlier, all the safety and health provisions were part of rules, state rules. And the exercise was, DG Fathi was making central rules, and based on that, they were making state rules. I would say DG Fathi was making model rules, which is not having any authority. We only recommend to them, and they adopted them as a state rule. That model rule process, we used to call chief inspectors, our own experts, and sit them, and we make a rule. Now the point is, the state government also makes rules in making the provisions under the code operable. For example, they make, even I will be surprised, the rules regarding the welfare is also made by central government only, not by the state government. So, rules on safety, health, working condition, welfare will be declared by central government only. State government will be implementing it because there are a lot of variations in the country. So it has been made. So the safety and health provision will remain throughout the country uniform by declaring it by the central government. Whereas, operationalizing part, licensing form, fees, registration, and the notices, forms, they are having their own rules to declare. Did I answer your question?
Hello, sir. Sorry to interrupt.
Yeah.
Yes, sir. Yes, sir.
Hello.
Right.
Please carry on.
Sir, our labor codes are coming under the concurrent laws of our country. So whether the state government can also make some rules and regulation for the same thing. So for that one, any amendment for the concurrent list or anything has been obtained by the central government, sir, regarding this?
Sir, there is no need, I'll tell you, because the government, state governments are given powers to make rules, number one. But they will not make standards, safety and health standard. Difference is this. Safety and health standard will be uniform throughout the country, because if you see the National Advisory Board, you have the state representatives, principal secretary, chief inspectors. So the state government being concurrent subject, their views are also taken into account. And of course, they have the provision to make rules other than safety and health. Agreed?
Okay. So regarding only the standards, the central government law is applicable.
And even rules
and
also.
regulations can be made by the state government.
See, I told you rules on creche, canteen, rest shade, all those rules also central government declares. But that is as per the suggestion of the National Advisory Occupational Safety and Health Board. And that board has the state representation.
Okay. Got it.
Thank you.
Thank you, sir.
Sir, one small question, sir. Once those regulations, standards, all these things come made by central government, then this state rules will be superseded by them, or still both will be in vogue? State rules are also there and central standards are also there.
I have understood your question. One is when the Factories Act is subsumed. You see the first slide. I have clearly stated when the Act is subsumed, the rules and regulations made under the particular Act also will be subsumed.
Okay, sir. Okay, sir.
Then under the new code, the central government will declare safety and health standards and rules on safety, health and working condition. State government has been given to make powers to make rules other than the safety and health and the working conditions. They will make rules. Appropriate government will make, and everything will come into force. What are all existing as of now are deemed to have been subsumed in toto under the code. And they will have no relevance once the code is started implemented.
Okay, sir. Okay, sir.
Right.
But actually, there is a doubt, confusion that somewhere we are mentioning this appropriate government, that is state government, instead of central government that directives or that instructions. So how can say that which will supersede? Just sir has asked, no. So appropriate government means we have to follow those rules only.
Yes, sir. If you see the code, wherever the appropriate government, they've written the word appropriate government.
Okay, okay.
That will come only when the section says appropriate government. When the code itself says central government, the question of appropriate government will not come there.
Okay, sir.
Areas have been identified under the, I will also, you can see in my presentation, the word is used, appropriate government. Okay?
Okay, sir.
Yeah. Now it comes to section 19. It is the duty of the state or central government can notify to conduct research experiments and demonstrations relating to safety and health and submit the recommendation to the central or state government. Then we also, the government permits the chief inspector of factories and then DG Faculty, DGMS, DGHS to do occupational safety and health survey in these establishments. Then the code provides for collection of data, particularly analyze occupational safety and statistics data collection. And also, it shall also maintain a database on interstate migrant workers electronically or otherwise in a portal. So, it provides authority to the central government to collect OSH data on the national basis, as well as the data pertaining to interstate migrant workers. Then, safety committee and safety officers. One of the delegates has raised the question. The appropriate government may by general order or special order require establishment or class of establishment to constitute safety committee. Now you see the word of appropriate government being the state government will make rule under section 22(1) and they will implement. You understand? So when I prescribe appropriate government, here central government will not come.
Yes, sir.
And again, you can see the as may be prescribed by the appropriate government. Wherever the word, for example, you take the Mines Act. Mines appropriate government is declared as central government. Only central government will be referred. Major port, appropriate government is the central government. Minor port, appropriate government is the state government. Like that it should be interpreted. And they have said, every establishment, if it is a factory on hazardous process, all factories, there should be a safety officer. If there are employment of 500 more workers, if it is hazardous process, for every 250 workers or more, there should be a safety officer. And the slab also, such number of safety officers, the appropriate government will declare. Then we come to chapter 5. As I told you, health, safety and working conditions. Again, you can see here, the central government will provide rules on cleanliness, hygiene, ventilation, temperature, humidity, environment free from dust, noxious gas, fumes, adequate standards of humidification, drinking water, overcrowding, everything will come there. Lighting, latrine and urinal accommodation, waste and effluent disposal, treatment and other things. So what happened? All this 23 is coming out here. And again, welfare provisions, the central government will declare. Adequate facility for washing, bathing facility, locker room, places for keeping clothing which are not worn during working hours, drying of wet clothing, sitting arrangement, canteen, and first aid box, everything, it all be adequate number of first aid box will be declared by the central government. One second, please. Hello. Yeah. No, thank you. Then we come to next chapter, hours of work and annual leave with wages. I think this I will skip because this is not relevant to today's point of discussion. If anyone has some point to discuss, we can ask this because this is not directly linked to today's meeting. I'm skipping that. Okay. So we come to the register part, register, record and filing of returns. Always the code clearly talks about maintaining the records, returns, filing return and registers in the electronic format. And those will be declared by the appropriate government. Here the appropriate government role has been clearly defined. Then comes the chapter 9, inspector cum facilitator or any other authority. So the appropriate government can appoint, you can see here, can appoint inspector cum facilitators for the purpose of the code. Is a very already existing, but they will be redesignated. And very important point, the appropriate government may lay down an inspection scheme. They shall lay down an inspection scheme, web-based inspection, calling for information under this code electronically, and such scheme shall inter alia have provisions to cater the special circumstances for assigning inspection and calling for information from establishment and so on. And also should provide for randomized selection of establishment as well as inspector cum facilitator for inspection. This is the kind of, the reforms, inspection reforms the government has brought in here. This is a very important issue. Randomized selection of the factory and randomized selection of the inspector himself. And there shall be an inspection scheme. And of course, then we come to powers. Same powers, they can enter with assistance.
Hello.
Yes, please.
So,
Yeah, please ask.
sir, when comes to randomized selection of establishment, inspector cum facilitator can inspect a particular establishment at any number of times. If he wants to inspect an establishment like 3 to 4 times, or he wants to make some point to that establishment to make some continuous inspection. He wants to do some continuous inspection. So at that time, this much number of times only he can able to inspect. Like that, any parameter is there, sir. Because he cannot force establishment for continuously daily inspection or weekly inspection. That kind of any restrictions.
Okay, you have got a very right question. I came back to the same slide. The appropriate government will have an inspection scheme. For example, you see currently like non-hazardous, non-dangerous once in 5 years, hazardous process oriented industries once in 6 months, dangerous operations once in a year. There can be many type of periodicity of inspection what you're talking. Agree?
Yes, sir.
That will be part of the inspection scheme. Number one. Definitely that can't be daily inspection.
Sir, other than that.
Let me
Other than that.
No, please wait. Let me answer this question. Then you come back to me. So having a scheme prescribed, they can't be like every day you can inspect. That is completely ruled out. And second point, again I have highlighted web-based inspection. It is already started implemented. It is being followed in many states. When an inspector comes and touches a screen of the computer tells him which factory he should go. He has no right to choose in this way. So this is called web-based inspection. There will be random, as you say, periodicity, location, and when they did, what is the due date, everything comes. That is called web-based scheme. And the inspection scheme also consists of team inspection, not the individual inspection. So all the components, what you have said, will be part of the inspection scheme and web-based inspection. What I mean by randomized selection is a very important issue. The establishment will be selected randomly by the computer, and the inspector also will be selected randomly. The idea here is the inspector sitting in the local area will not do inspection. Inspector may come from any other place who doesn't have any contact to you, who doesn't have any proximity to you. He can be an inspector for that particular inspection. Now you please raise your views.
Is that the same like income tax file returns? That's randomized selection, like randomly selecting the officer as well as the returns. So
same scheme.
Sir, one doubt.
Thank you, sir.
Only one thing is the randomized in selecting the install. For example, today in this month, in one particular state, the inspection is there for some 100 industries, which are normal, maybe some dangerous operations, maybe 50, hazardous industries, some 100, like that number is there. It will be random. Today it may come your turn may come after 15 days on the 30th day. There is one issue there. Inspector is random, but randomized selection of establishment is eligible establishments will be randomized on a particular date. As you rightly said, by and large the income tax model.
Sir, one thing, sir.
Thank you,
You
sir.
told about this inspection scheme. So will it be known to both this inspector cum facilitator as well as the employer also?
Yeah, already they have said, I know a few states, they are uploading in the public domain when the committee will inspect.
Okay. And what about this this inspection team? This will be the within the state, or they can come from the outside of the state also? Other state also can
Who is doing
inspect.
this? Please see the top one. Who is doing?
Appropriate government. That means within the state.
No, state government. They can decide to call other state also.
Okay.
That is their issue. They can call inspector from adjoining states also. Normally it doesn't
Okay,
happen,
sir. Okay, sir.
but it doesn't restrict them. Shall I proceed?
Yes, sir.
Yes, sir. Yes, sir.
And you see here, power, same power they have given. I'll skip this. And there is a power given to district magistrate. There's nothing but district collector can exercise the powers of and duties of inspector cum facilitator in terms of mines, not in terms of factory. Another important decision under this code, another provision is the third-party audit and certification. So they create a third-party certifications by empaneling experts through a scheme, and these people will be auditing and giving a report. And again, the scheme is yet to be evolved. And again, you see here, third-party audit and certification in a randomized manner through web-based scheme. The auditor also will not be the choice of the employer. Again, it will be system has to be randomized through a web-based scheme, so that you can't choose your own auditor. Understand?
Sir, one thing, sir. This talks about the safety audit, third-party audit, where at present the employer or the occupier is giving the contract to for the third-party audit. Is it talks about that audit?
It is not safety audit. There is a third-party audit for the entire code.
Okay. Oh, okay, sir.
This includes safety and health and working conditions and other provisions. So safety audit is also part of this. Agreed?
Yes, right, sir. Right, sir.
I move on to the next provision. The inspector cum facilitator shall maintain the secrecy of information. Then we have the employer shall offer the facilities required for making inspection, survey, measurement, examination under the code. Then 42 provides for the medical officer, which is nothing but the certifying surgeon. You see, the appropriate government may appoint. They remove the word certifying surgeon, they're calling them as medical practitioner, medical officer for the purpose of factory. That is within the department. Then comes his duties. Basically, there are three duties of the medical officer appointed by the government. One is examination and certification of the workers, dangerous operations and hazardous processes. Then we have medical supervision of the workplace. Third will be adolescent certification, age certification. These are the three works of the medical officer appointed as section 42 of the code. So, any doubt at this point, or I'll move to the next chapter?
So the medical examination of workers.
Yeah, please.
So the medical examination of workers, that should be done under certification of certifying surgeon, right, sir?
Yeah.
Not the medical officer of the plant.
Yeah. Now you see, I have clearly stated the certifying surgeon will be called as medical officer by and large.
Okay.
Because appropriate government is appointing medical practitioner with the prescribed qualification to be medical officer.
Okay, sir.
To simply say, the certifying surgeon will be referred as medical officers under the code.
Okay, sir. Okay, sir. I understood that. But see, in factories also we deploy our own medical officers, as you have defined in previous slides. On definition. If our own plant medical officer does this same job, the medical examination of workers who are exposed to hazardous processes and all, that doesn't comply with the code, is it, sir? It should be.
I will tell you that. No, I understood your point. I'll explain that.
Yes, sir.
The factory medical officer having AFH examination and doing some qualification, doing examination will be part of the safety net standard. Okay, where the government doctor, certifying surgeon should medically examine the certification shall be prescribed.
Okay, sir.
This is something over and above what the factory medical officer is doing. This does not take away the factory medical officer examination as it is. It is even the current law also, please read section 10 of the Factories Act, they have the power to do examination again.
Yes, sir.
So that is it's similar to that. It doesn't take away your factory medical officer's powers to do examination and certification.
Sir, actually, workers who are getting a medical fitness certificate, normally the certificate issued by our company medical practitioner or some PSC, suppose there is a PSC primary health center of the government, still that PSC doctor's certification is not acceptable. Why it is so?
Now you see, the appropriate government may appoint, number one, the appropriate government can be appointed person, can be a certifying surgeon. And second is, it also says where he should do examination, prescribe kar rahe. And this does not take out the powers of the factory medical officers. And this is not something new. You please go to section 10 of the Factories Act. Currently also the same provision is available. Whether they are practicing it or not is a different issue. Did I clarify your point?
Yes, sir. Yes, sir.
Thank you. So coming to the women employees, see, there is a thing that the women employees are permitted even after 7 p.m. also and before 6 a.m. This is a right to equality. And they are what happening, once they are permitted, they will be permitted to such conditions on safety, holidays and working hours, and they are eligible, like the Honorable High Courts come out with a lot of guidelines. Those things will be followed, like pick up from work, residents to work and dropping back at workplace, ensuring their safety and security. In case of ending of shift in the midnight or in the night, facilities to stay, and their security is taken care of. Safety gadgets are given, all those things. Only thing is, the prohibition of women beyond 7 p.m. is taken out and they are permitted throughout the day, including the night. And coming to the safety of employment of women in dangerous operation, and they can adequate safeguards prior to employment of women, it is prescribed. In fact, it is not prohibition. It talks about providing safeguards to the employment of women in such hazardous or dangerous operations. Only the law prohibits pregnant women from getting employed. Then I come to factories. The licensing and approval part, you must be knowing the same thing, it is there. And we have liability of owner of premises in certain, one second, yeah, I'm in a meeting now, 15 minutes I'll call you. So liability of owners of premises in certain cases is a very important issue. The owners are also liable. Basically, there may be a big complex having multiple factories. Then the owner of the premises or occupiers of the factories shall be responsible individually and jointly for maintaining and providing such common facilities and services. It's not only the occupier, it's also now it shifts to owner of the premises. This is another important change in the current code. And this power to apply the code to certain premises, this is in line with the section 85(1) of the Factories Act. Irrespective of the number of workers, it can be made applicable to other factories also by the appropriate government, considering the risk and other issues involved. Then this is the dangerous operation, what you have section 87, same thing we have provided. In the site appraisal committee, which is a mandatory run for the hazardous industries, same thing has been provided. Compulsory disclosure of information by the occupier is a must, current provision, and specific responsibility of the occupier in relation to hazardous process. A board to inquire certain situations, the board can inquire into accidents, certain situations, and the central government reserve the right to declare emergency standard. Then the permissible limits of exposure of chemicals, what is there currently under the Factories Act under section Schedule 2 will be declared by the state government, which will be part of their rules, because you see now the prescribed by the state government. This is what the law says. It will be moving from central sphere to state sphere, and worker have the right to warn against imminent danger. This is equivalent to 41H. The worker refused to work in case of safety related issues, and he should respond to the occupier, and if the occupier could not solve the issue, then he should respond to inspector cum facilitator. And 90 talks about appeal against the order of the inspector. Any order passed by the inspector cum facilitator, he can appeal. And this is the exempting rules powers given to appropriate government. Now I come to the important section, penalty part. Any doubts at this point we can address? If not, I'll move to the next slide. No doubt, I will move to the penalty part. It's a very important thing. You can see here, the employer or the principal employer of the establishment are responsible. The shift is there from occupier and manager, because occupier is already an employer and manager is an employer. Only penalty is given not less than 3 lakhs, as well as which may extend to not less than 2 lakhs, which may extend to 3 lakhs. And if it is continued, then it is 2,000 rupees per each day. The imprisonment class under section 92 of the Factories Act has been removed. And whereas obstructing the inspector, then you can say that punishable with an imprisonment as well as fine. Only when you obstruct, imprisonment class is coming, fine which may extend to 1 lakh rupees. Maintaining registers, you see here any person, anyone who is vested with the responsibility to maintain the registers. So that person he shall be liable for penalty not less than 50,000 rupees, which may extend to 2 lakh. Again, is a penalty, no imprisonment. Section 97, for the provision of the code, rule, regulation, and all those things, if the order is passed, fine shall not be less than 50,000 rupees, which may extend to 1 lakh rupees, again in terms of money. The punishment of for falsification of record, punishable with an imprisonment for a term which may extend to 6 months. Again, falsification of record, imprisonment clause is there, or with fine. There is no question of and. Then if there is a penalty for omission to furnish plan, the penalty not less than 1 lakh. Again, penalty is there, no imprisonment clause. Punishment for disclosure of information, there is an imprisonment clause, 3 months imprisonment up to 3 months, a fine which may extend to 1 lakh or both. Wrongfully disclosing the results of an analysis, again extend to 6 months with fine, which may extend to 50,000 rupees or both. Contravention relating to provisions of hazardous process, and you can see be punishable with a term of 2 years and with fine. This is an important. This is the only provision relating to hazardous process, that's particularly section 6, 13 and section 80. Then the imprisonment clause is made mandatory. Punishment for contravention of provisions of duties relating to safety, then which can be, imprisonment is quite stringent here, may extend to 2 years and fine not less than 5 lakh rupees. This is the contravention of duties relating to safety and health provision. And if it is serious bodily injury, imprisonment which may extend to 1 year, punishment which may extend to 2 lakh rupees. The court may direct the portion of the fine, and again an important issue, portion of the fine shall not be less than 50% and shall be given to the compensation. This is a very important issue. Upon the court penalty, 50% of the money shall be given to the victim or the legal heirs of the victim in case of death. Then comes, contraventions regarding general and special order. Then again it says about imprisonment clause is there, 104. Then offences by employees, penalty is only money. It has been now made 1,000 rupees, may extend to 10,000 rupees. And then exemption of the owner or agent or manager or occupier from factory liability, the law provides for exemption. It's also another important issue. The company can also be made punishable. It's not only individuals, the companies also can be made punishable for conduct of the business in an unsafe manner, violating the rules and regulations. And you can see any director, manager, company secretary, such director, manager, company secretary or other officers shall be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. Then we have company, they have defined what is company, all those things. There is a limitation of prosecution. It clearly says existing 3 months has been shifted to 6 months. Because what happened, the law clearly provides for, if the violation is pointed out, if the employer complies with the provisions, no proceeding shall lie against him. Suppose you can see here, within a period of 30 days from the date of notice. So give an opportunity to the employer, highlighting the violation, and if he complies with, there can't be any prosecution lie against him. And now the period of limitation for filing charge sheet has been increased from 3 to 6 months. And of course, Metropolitan Magistrate or Judicial Magistrate first class shall try the offences under this code and rules and regulation made thereunder. Then comes the Appropriate government, certain cases, there are inquiry and all that. I don't want to do it. Then power of the court can make orders. Then that can be, it's a very important issue. The composition of offences, nothing but compounding of offences. So the management or the employer can go for compounding, paying penalty for that offence, and he can get away from the legal prosecution. In case of a penalty, then 50% of the maximum penalty shall be given. In case of an offence, for a sum of 70% of the maximum penalty that you are paid, and compounding can happen. And I don't want to go to the social security because it's not part of this. Delegation of powers have been given, and onus to age, as usual, the burden to prove age lies on the accused. That is the current provision, age of employee. And common license, the court provides for common license for contractor, factories and industrial premises. There can be single license for contractor and factories. There can be multiple licenses. And of course, the power of the government to direct inquiry, conduct inquiry, report publication, restriction of information, and civil courts are barred because the criminal law, civil courts cannot proceed on this. No suit or prosecution or other legal proceedings shall lie against any person who has done in good faith or intended to be done in pursuance of the court. Power to exempt, and power to exempt during public emergency. Then power to remove difficulty or routine thing. These are the power given to appropriate. Somebody was asking. Appropriate government has been given power to make rules. These are the areas for which they can make rules. Central government to make rules in central sphere. State government to make rules in their sphere. And it also talks about publication. You can see all the rules, regulations, bylaws under this code, shall not be given 45 days, minimum 45 days, a draft in the public and take the comments and then notified it. And you can say, proposal be taken into consideration, draft proposed, and they shall be published in the official gazette. There are bylaws and so on. And there is a power, central government can make any rules, may make rules regulating general safety. It's a very important issue. This 140 provide powers to the central government to provide for safety and health requirement of the persons residing anywhere, like any operation. It need not be a factory, it need not be a construction site. For example, sewage cleaning or any other type of work, the government can prescribe rules to regulate safety and health of the persons residing in India. And of course, repeals and savings. And this is the first schedule, what you have given. Up to 29, what is there? And we have added, all the government has added. Very important point is the serial number 40 of the Hazardous process. The operations which may give rise to notifiable diseases are declared as hazardous process so that adequate precautions are taken care so that such notifiable disease cannot occur in a workplace. Then this is the second schedule, as I told you, the list of matters for which the board can make standards. All those safety things are given here. Then we have type schedule in line with your Factories Act. Now it is applicable to all the establishment. To summarize, it talks about third-party audit certification, employment of women and safety of women in dangerous operation, unified registration and license, electronic maintenance of records, furnishing of results, serving of notice. Even notice serving also electronic, no hard copy. Compounding of offences, enhanced penalties, and of course, thresholds, we have put safety officer 500 for a factory, if it is hazardous process 250, welfare officer 250 for factory, for every 250 workers there should be a welfare officer, canteen 100 workers, creche 50 workers, license for contract labor 50 workers, BD and CR 1 worker. And as I told you, registration 10, annual checkup is given as it is under the law. I think with this, I come to the end of the presentation. I think now the session is open for any question, answer, or clarification. Thank you very much.
Which is appropriate for a JV company like NTPC, sir?
What is it?
Which is the appropriate government for a JV company like NTPC? There's 50-50 JV between NTPC, a central PSU, and the Transit-Co.
Sir,
So
for all the factories, appropriate government is the state government.
Okay.
Whether it is in central sphere or state sphere, whatever it is.
Okay. Okay. Thank you.
So what is the timeline for implement this OSHWC code in future?
No, the government will take the call. I don't think the government will take the call regarding the timeline, because now the expert committees, there are a lot of procedures involved. The government will take a call on this.
Okay, so yet not finalized.
It is under process.
Okay, got it. Thank you.
Thank you. Any other point? If not, then I'll give a mic to Madam.
Yes, sir.
Yes, sir. Yes,
Ma'am, one question. Sir, actually, is there any change in the labor license, which was earlier 20 numbers? Is it 50 now, or it is remains same?
A threshold already given. I have told you, threshold has been shifted from, see, registration is 10. That is one-time registration online, electronically. License application of the law, it is 20 with power on any one day in the preceding 12 months, or 40 without power on any day preceding 12 months.
Okay.
Do we have any other query? Participants who are having any other queries related to this subject may kindly post it immediately, please. Fine, then, with no questions coming on, I think it's time for us to close the session. On behalf of NTCL family, I take it a great privilege in extending our heartfelt thanks to our faculty of the day, Dr. Elangovan sir, Director General from Labor Ministry. Thank you, sir. Thank you for taking out your valuable time in explaining and demystifying the concepts behind this code. It was indeed an interesting and intriguing session, loaded with lots of information and the clarity over the subject.
Thank you very much.
I also thank our NTCL.
Yeah.
Yes, sir. Yes, sir. It's a pleasure, sir. I thank our NTCL management and safety department headed by DGM Safety and Shri G.S. Rao sir and Ramaswamy sir, AGM Safety, for guiding us through this whole concept and for giving us the link to have the veteran faculty like you for holding this wonderful session. Hope this session was very useful to all the participants who joined from NTCL and NTPC and from other projects across India. Thank you one and all for joining us and getting benefited. Hope the learnings of today's training program is being carried out. Hope all your queries regarding this particular code has been clarified at our end as well. Hope to have more such interesting session through you, sir.
Thank you, Ma. It's a pleasure. I would like to, record my appreciation, Mr. Rao, Madam Andal. They have been very constantly persuading me. Today, this is my third meeting. Morning, there was one meeting, there was another meeting with secretary, then again 2 o'clock one meeting. And it's a pleasure sharing the information. I believe that the delegates might have benefited listening this. Please write to us, write to me, talk to me if there is any further clarification or support. And I thank the delegates and specifically NTUCL, the management, and in particular Mr. Rao and Madam Mandal and their team for taking up this initiative, including your CEO and so on. I also request you to share the details of the participants by mail so that I will take it on official and we'll also put it on record. Thank you once again for all of you for patient hearing. Very valid questions, fully reflecting the ground realities. And of course, I'm really convinced, I'm happy that I could make a presentation which could have benefited you in a bigger way. Thank you very much.
Thank you, sir.
sir.
Thanks a lot, sir.
Thank
It's a
you.
Thanks a
immense
lot.
pleasure to have you, sir.
Thanks a lot, sir.
Thanks a lot, sir.
Thank you.